In the simplest terms, contract management is the process of managing contracts. This includes everything from creating contracts to negotiating them to tracking their performance and ensuring compliance. It sounds straightforward, but effective contract management is crucial for any business that wants to avoid risks and maximize the value of its agreements. Think of contracts as the rules of the game in business. They define the terms of your relationships with customers, suppliers, employees, and other stakeholders. Without clear contracts and a system for managing them, you're essentially flying blind and exposing yourself to potential disputes, financial losses, and reputational damage. Whether you're a small startup or a large corporation, contract management plays a vital role in your success. It ensures that your agreements are legally sound, protect your interests, and help you achieve your business objectives. Effective contract management is not just about avoiding legal problems, it's about gaining a competitive edge. When you manage your contracts well, you create a more efficient and profitable business. Firstly, it minimizes financial risks. By carefully drafting and negotiating contracts, businesses can avoid costly disputes and ensure that they are getting the most favorable terms. This includes things like securing the best prices from suppliers, protecting your intellectual property, and limiting your liability in case something goes wrong. Secondly, good contract management improves operational efficiency. It streamlines the contract lifecycle from creation to renewal, making it easier to track deadlines, obligations, and performance. This frees up your team to focus on more strategic tasks instead of getting bogged down in paperwork. Lastly, robust contract management builds stronger relationships. Clear and well-managed contracts foster trust and transparency with your partners, leading to smoother collaborations and long-term growth. The contract management lifecycle typically involves several key stages. Creation. This is where you define the scope of work, payment terms, deadlines, and other crucial details. It's essential to have a clear understanding of your needs and to draft contracts that are unambiguous and legally sound. Negotiation. Both parties discuss and agree on the terms of the contract. This may involve some back and forth to find mutually acceptable solutions. Execution. Once both parties have agreed to the terms, the contract is signed and it becomes legally binding. Monitoring and compliance. This involves tracking deadlines, deliverables, and obligations outlined in the contract. It's crucial to have a system in place to ensure that both parties are fulfilling their contractual duties. Amendments and changes. Contracts are not set in stone. As business needs evolve, you may need to make changes to the original agreement. This requires careful documentation and agreement from all parties involved. Risk management. Identifying and mitigating potential risks associated with a contract is essential. This might include things like non-performance by the other party, changes in market conditions or unforeseen circumstances, renewal or termination. When a contract reaches the end of its term, you'll need to decide whether to renew it, renegotiate it, or let it expire. Each stage of the contract lifecycle is equally important. By having a systematic approach to managing contracts from start to finish, businesses can mitigate risks, avoid costly mistakes, and ensure they're getting the most out of their agreements. Section 4. Common pitfalls in contract management. Even with the best intentions, contract management can be tricky. Here are some common pitfalls that businesses often encounter. Poor contract drafting. Unclear language, missing clauses, or ambiguous terms can lead to misunderstandings, disputes, and legal headaches down the road. Inadequate risk assessment. Failing to identify and address potential risks associated with a contract can result in unexpected costs, delays, and reputational damage. Lack of centralized system. Storing contracts in different locations, using manual tracking methods or relying on spreadsheets can lead to version control issues, missed deadlines, and difficulty in locating critical information. Ineffective communication. Poor communication between parties involved in a contract can create misunderstandings, delays, and disputes. Ignoring contract renewals, failing to track contract end dates, can result in automatic renewals with unfavorable terms or missed opportunities to renegotiate better deals. These pitfalls can have serious consequences for businesses of all sizes. They can lead to financial losses, damage to your reputation, and strained relationships with clients and partners. Section 5. Best practices to avoid contract management issues. The good news is that many of these pitfalls can be avoided by implementing best practices. Use clear and concise language. Avoid legal jargon and technical terms that the other party might not understand. Keep sentences short and to the point. Establish a centralized repository. Invest in a contract management software or system to store all your contracts in one secure location. This will make it easier to track deadlines, access information, and ensure everyone is working with the latest version. Implement a contract review process. Have a standardized process for reviewing and approving contracts before they are signed. This will help ensure that all agreements meet your legal and business requirements. Asterisk. Prioritize communication. Establish clear lines of communication between all parties involved in a contract. Regularly update stakeholders on the status of the agreement and address any questions or concerns promptly. Use contract management software. Consider using contract management software to automate tasks such as tracking deadlines, sending reminders, and generating reports. This will free up your team to focus on more strategic work. By implementing these best practices, businesses can streamline their contract management processes, reduce risks, and improve their overall efficiency. Section 6. Conclusion. Reaping the rewards of sound contract management. Effective contract management is not just a box to be checked, it's an ongoing process that requires attention to detail, clear communication, and a commitment to best practices. When done well, contract management can be a powerful tool for driving business success. It helps you mitigate risks, optimize your contracts, improve your bottom line, and build stronger relationships with your partners. In today's increasingly complex business environment, having a solid contract management system in place is no longer a luxury. It's a necessity. Pause 3S. Section 7. The intersection of contract management and arbitration. Contract management and arbitration are closely related in the context of business and legal operations. Contract management involves overseeing and administering contracts to ensure that the parties fulfill their obligations, while arbitration is a method of resolving disputes that may arise during the contract's execution. Here's how they intersect and the key considerations for both. Effective contract management begins with drafting clear and comprehensive contract terms. This reduces the likelihood of misunderstandings and disputes that could later require arbitration. Regular monitoring of the contract's performance ensures that both parties adhere to their obligations. This proactive approach can prevent disputes over non-performance, delays, or breaches. Proper documentation of communications, changes, and performance under the contract is crucial. In the event of a dispute, these records can provide evidence in arbitration proceedings. Most contracts include an arbitration clause, which specifies that any disputes arising from the contract will be resolved through arbitration rather than litigation. This clause outlines the process, rules, and location for arbitration. The arbitration clause should clearly define the types of disputes that are subject to arbitration. This may include issues like breaches of contract, payment disputes, or interpretation of contract terms. Contract managers should work with legal teams to draft precise dispute resolution clauses that specify arbitration as the preferred method. This includes determining the rules, for example, ICC UNCITRAL, the seat of arbitration, and the language of the proceedings. While managing a contract, parties should always be mindful of the possibility of disputes. This means ensuring that all actions are well documented and that any changes to the contract are formalized through amendments or addendums. Arbitration is generally faster and less formal than court litigation, making it an attractive option for resolving contract disputes. Arbitration proceedings are private, which helps protect the confidentiality of sensitive business information that may be discussed during the dispute. Parties can select arbitrators with specific expertise relevant to the contract's subject matter, ensuring that the dispute is evaluated by someone knowledgeable in the field. While arbitration awards are generally enforceable under the New York Convention, issues can arise in certain jurisdictions or if the award is challenged in court. Although typically less expensive than litigation, arbitration can still be costly, especially if the process is drawn out or if multiple arbitrators are involved. Arbitration decisions are usually final, with limited grounds for appeal. This can be a disadvantage if a party believes the arbitrator made an error. During contract negotiation, parties should carefully consider and agree on the arbitration clause, including the rules and procedures that will govern any disputes. Throughout the life of the contract managers should be vigilant in ensuring compliance and addressing potential issues early to avoid disputes that could escalate to arbitration. If a dispute arises, the contract's arbitration clause will guide the resolution process. Contract managers may need to coordinate with legal teams to prepare for arbitration, including gathering relevant documentation and selecting an arbitrator. Contract managers should be trained in the fundamentals of arbitration and dispute resolution to better manage contracts with potential disputes in mind. Contract management software can help track performance, deadlines and compliance, reducing the likelihood of disputes that could lead to arbitration. Periodically reviewing contracts and their performance can help identify potential issues before they escalate, allowing for early resolution or negotiation rather than arbitration. After an arbitration award is issued, the contract management team may need to implement the award's terms, whether that means adjusting the contract, making payments, or fulfilling other obligations. Analyze disputes that have gone to arbitration to learn how contract management practices can be improved in the future to prevent similar issues. Effective contract management is essential for minimizing the risk of disputes that may require arbitration. When arbitration is necessary, a well-drafted arbitration clause and proper contract management can make the process smoother and more predictable. Contract managers play a key role in both preventing disputes and managing the arbitration process when disputes arise, ensuring that contracts are executed smoothly and that any issues are resolved efficiently.